Good evening, everyone, and welcome to the University of Tasmania's Island of Ideas public talk series. Tonight, the university partners with the Australian Red Cross to bring you the 2025 Red Cross Oration titled Safeguarding the Vulnerable in Conflict. I'm Cleo Hanson-Laurie, and I'm a lecturer here at the university's Faculty of Law, where my research focuses on refugee law and forced displacement. Having worked with the Australian Red Cross some years ago as a humanitarian observer in their immigration detention program, I have a strong appreciation of the invaluable work Red Cross does in helping people impacted by conflict and humanitarian crises. This evening, we are broadcasting to you from Lutruwita, Tasmania, the unceded land of the Palawa people, the original and continuing custodians of this land, sea and waterways. For those of us here in person, we are meeting on Muwinina land, and we pay our deepest respects to the past elders of the Muwinina people and to the past, present and emerging elders of all Palawa people. As we gather in Nipaluna, Hobart, and talk about how we might safeguard children, women, and other people made vulnerable by conflict, it would be remiss of us not to first recognise the history of dispossession and forced displacement of the Tasmanian Aboriginal people, and all that has been lost as a result. Our university stands for a future that profoundly respects and acknowledges Aboriginal perspectives, culture, language and history, and a continued fight for Aboriginal justice and rights. If you are joining us online tonight, please feel free to share your own acknowledgement in the Q&A function at the bottom of your window. The university also wishes to recognise honoured guests who are in the room, including Vanessa Goodall, State Director of the Australian Red Cross. Since its inception in 2007, the Red Cross Oration has sought to honour the principles and priorities of the International Red Cross and Red Crescent movement, principles that have been forged in some of humanity's darkest hours. Now in its 18th year, this lecture series continues to bring into focus not only the operational realities of humanitarian work, but also the enduring moral questions that accompany it. Tonight, we carry forward that legacy. In a world increasingly shaped by conflict, environmental disasters, and humanitarian crises, the need to uphold human dignity and to protect those made vulnerable is more important than ever. At present, mechanisms to protect people in such contexts are increasingly fragile. We see humanitarian access being restricted, the international humanitarian law and human rights law being violated, and too often the voices of communities affected are unheard. These types of events can amplify existing vulnerabilities within a society for certain groups, including women, children, Indigenous peoples, older persons, people with disability, and those with limited means, to name a few. This is a good point to emphasise that vulnerability is not an intrinsic trait. Rather, it is often the result of external forces that place people at greater risk of harm. These forces might be specific threats or pre-existing patterns of violence and structural discrimination. In our current global landscape, protecting people at risk of harm presents complex challenges for humanitarian actors. Tonight, our speakers will share their own experiences and perspectives on protecting people in the field in some of the world's most volatile environments, as well as through judicial processes that allow for the voices of survivors of gender-based violence and other harms to be heard. This is not merely a professional concern, of course. It speaks to our shared values about how we protect the dignity of others, especially when it is inconvenient or dangerous to do so. Here in Tasmania, we're physically distant from many of these crises, but we are not intellectually or morally removed from them. So tonight, I invite you to listen not only to our speakers' stories, but the questions they raise. What does it truly mean to protect people at risk? How can we meaningfully and sensitively ensure that the voices of survivors are included? And what does persistence look like in the face of despair? Whether in a war zone, in a courtroom, in a lecture theatre, or at a dinner table. It's now my pleasure to invite my colleague and friend, Professor Tim McCormack, to introduce you to tonight's speakers. Professor McCormack is a globally recognised authority on international humanitarian and criminal law. He recently concluded his role as Special Advisor on War Crimes to the Prosecutor of the International Criminal Court in The Hague and continues his work as Professor of International Law at the University of Tasmania. Tim was the inaugural Australian Red Cross Professor of International Humanitarian Law and recently celebrated 35 years of service to the Red Cross movement. Thank you, Tim.
Thank you, Cleo, for your introduction of me, of the context of tonight's Red Cross Oration, and also for such a sensitive and thoughtful acknowledgement of the Moanina people. It's my privilege and also my joy to introduce our two speakers for tonight. First, you will hear from Katrina Myerson, who is a lawyer and international humanitarian protection specialist. For the last 10 years, you would have found Katrina in some of the world's most challenging humanitarian crises. In Haiti, in Papua New Guinea, in the Democratic Republic of the Congo, in Jordan, dealing with the millions of refugees from the Syrian conflict, in Rwanda, in Afghanistan, or in Burma, in the Rakhine State. In all of that operational experience that Katrina's had, she's worked with the International Committee of the Red Cross, she's worked with UN agencies, she's worked with other NGOs. She has specialised in humanitarian protection in conflict and post-conflict contexts and focused on the conditions and the treatment of detainees, of prisoners of war, of civilian populations adversely impacted by armed conflict. Katrina is currently undertaking a PhD in the Asia Pacific Centre for the Responsibility to Protect at the University of Queensland. Responsibility to Protect, or R2P, is a legal framework for assigning responsibility to care for those the subject of international atrocity crimes when their own sovereign state is unwilling or incapable of doing that for them. And in this work that Katrina is now doing in a PhD, based, I'm sure, on all of that operational experience, she's attempting to bring critical analysis to the efficacy of principled international approaches to complex humanitarian challenges. After Katrina has spoken, we'll hear from Kim Toy-Seelinger. Kim is the director of the Centre for Human Rights, Gender and Migration at the Brown School of Public Health at Washington University in St. Louis, Missouri. The aim of that centre that Kim directs is to promote evidence-based solutions for challenges arising in the intersection of human rights violations, gender and migration. Lawyers are not sufficiently omni-skilled to be able to solve all of these complex challenges themselves. And Kim Seelinger, in my view, is an exemplary model of the importance of interdisciplinary, cross-disciplinary, transdisciplinary approaches to trying to solve such complex problems. This centre that she directs is based in the School of Public Health. She involves social scientists, practitioners, policy experts, as well as a few lawyers, all focused on applied research for practical implementation of solutions to complex challenges. Kim was formerly the special advisor on sexual violence in armed conflict to the prosecutor of the International Criminal Court. And when she was appointed to that role in 2021, I was already in my role as special advisor on war crimes. We met for the first time just under 4 years ago. But there are some people in life who you meet, and although it's a relatively short period of time that you've known them, they become deep friends. She's one of mine. I deeply admire Kim for her ability to bring people with complementary skill sets together to achieve positive outcomes. I've seen Kim in different contexts, including at the International Criminal Court, getting alongside trial teams. For a minute, I saw TTs on my notes and thought Thirsty Thursday, surely I wasn't going to say anything about that. But trial teams, investigators, military analysts, forensic experts, gaining their confidence and helping them think through the tasks that they have. She's built up tremendous trust amongst them and made a huge contribution to the work of the Office of the Prosecutor at the International Criminal Court. She's victim-oriented, she's trauma-informed, she's deeply sensitive and full of compassion and empathy. I think she's a great human being. And here's the joyous bit for me. Been asking her since I first met her to come to the heart-shaped island to be with us for a few days, and here she is. You're all privileged to hear from her tonight. Please join with me in welcoming Katrina to come to start the presentation. When she's finished, Kim will come up and also speak to us. Thank you.
Good evening, and thank you to the organisers for tonight. I'd like to start by taking you back to early 2018. In Myanmar's North Rakhine, the Rohingya crisis was still continuing to unfold. Often people fleeing the violence would congregate at beach areas, hoping to then secure passage over to Bangladesh. At times, families walked for days, carrying the elderly, children, and whatever they could manage. I'm sure you recall those images, those aerial shots of columns of desperate people trudging through the paddy fields. When people arrived at the beach, they were obviously exhausted. And during that time, often several days while they waited to continue their journey, they were basically just living on the beach with their families, out in the open, no facilities, very scarce supplies, only what they managed to bring. As part of the North Rakhine team for the International Committee of the Red Cross, the ICRC, we started to visit the beach quite regularly, bringing drinking water, simple shelter materials, or basic hygiene provisions. While it wasn't a massive trip from the town where we were based out to the beach, the route covered damaged roads, winding, narrow dirt tracks, and several checkpoints. One day the team arrived and we saw that there were not many people left on the beach, just a small group, obviously feeling very vulnerable and afraid, huddled under a makeshift shelter, afraid of who might be coming. When they saw it was the ICRC team, they slowly emerged. A woman had just given birth on the beach, out in the open, with no medical support, in unhygienic and horrible conditions. The ICRC nurse was on the team and was able to provide some medical care to both the mother and the newborn baby. Thank you. So both survived. This new life providing much needed hope in the face of devastation. Watching the news these days, it is easy to feel disheartened. As we've already heard, we're seeing these images from around the world of conflict and the suffering that they inflict. It's easy to wonder, can anything be done? Is there still a place for hope? With over 130 conflicts ongoing around the globe, the world is facing some serious challenges, around conduct of hostilities, the impact of war, and how the most vulnerable can be protected during hostilities. The ICRC has recently published a report on international humanitarian law and the challenges of contemporary armed conflict, and it outlines some of the major adversities that we're confronting on a global level. However, tonight I'm going to leave the big picture issues and I'm going to speak more about some of my personal experiences around the hazards and dilemmas that face humanitarian workers in the field every day and how we try to negotiate these complications to protect the most vulnerable in conflict. I'm going to speak firstly about the obstacles to accessing people in need. Secondly, I'm going to speak about working with armed actors who at times seem to neglect the laws of war. And lastly, about how we can work with communities to truly understand their capacities and their strengths and the threats while they're living in the shadow of conflict. As a key part of the humanitarian milieu, the ICRC, International Committee of the Red Cross, works in over 90 countries around the world to provide humanitarian protection and assistance to those affected by conflict. In doing so, there are many challenges. It is not easy, but humanity compels us to persist. Firstly, we persist to ensure access to vulnerable people. Working in conflict settings quite obviously brings some fairly serious safety risks to humanitarian personnel. And this has the flow-on effect and negative impacts on how we can access the people we're trying to assist. Shortly after I left Afghanistan, in 2017, I was shocked to hear the story around Lorena Embral Perez, a Red Cross physiotherapist who was working there with people who had lost limbs or people living with disabilities. She was shot, apparently by a patient while working in the rehabilitation centre. So how do we as humanitarians try to balance this kind of risk with the need to provide support to vulnerable people? There is no magic equation and no easy answers. As you may know, 2024 saw the deadliest year on record for humanitarian workers. The UN sources are saying 377 aid workers were killed. And these threats continue in 2025. Last month, there was a joint statement of the president of the ICRC and of the International Federation of the Red Cross and Red Crescent Societies, and they called for international action, noting that already this year, 10 personnel from that Red Cross, Red Crescent movement had been killed. And sadly, this number has already grown since then. And this brings me to a really important part. National humanitarian staff account for over 95% of the more than 600 cases of humanitarians being abducted, killed, or wounded in 2023. Think for a second, 95%. So it's our national colleagues that continue to work while their own houses are destroyed, while their families are torn apart. But there they are, turning up to work every day to help those around them. Our national colleagues are truly remarkable. And now more than ever, the safety of humanitarian workers remains a daily challenge in the field and one that has a significant impact on vulnerable people. Access to communities can also be hindered by the armed groups or the authorities that control the areas we're trying to reach. So permission to travel in certain areas may be denied. Red tape and paperwork can hold up assistance for months sometimes, and checkpoints can pose a constant obstacle. I've driven 5 hours to a place of detention to undertake a pre-arranged, pre-authorised visit, only to be refused entry upon arrival. Now, these refusals and restrictions, I mean, they can be for valid safety concerns of humanitarian staff. Conversely, they can be based on perhaps a fear or mistrust of external personnel, maybe what they will see, what they may speak out about, or suspicions of hidden agendas of international organisations. But sadly, we also see denial of humanitarian access used as part of a military strategy of deprivation or as a means to continue inhumane activity without interruption. Finally, reaching communities can also be really complicated by remote locations and difficult terrain. So when I was working in Mongdo, North Rakhine, to get to our sub-delegation, from Yangon, we would fly, then we would take several hours on a speedboat and then four-wheel drives over the mountains just to get to where we were based. And from there, we would travel sometimes 5 hours or so one way, usually on dirt tracks, then maybe continue on foot to reach communities. In the wet season, this was even more complicated, and we'd often get stuck in mud or the floodwaters meant we couldn't pass. So, you know, we'd go on foot when we could, sometimes take small boats, but some areas we just couldn't reach. On one occasion, part of the road had collapsed, and so the four-wheel drive was stuck. They couldn't pass. So the team went to the local market, gathered what materials they could, and created a makeshift bridge. Not strong enough to carry a Land Cruiser, but enough so that the team could put water into small containers and ferry it across on local motorbikes. So this meant at least the team could still access the displaced people and still provide life-saving water. So it is certainly not always easy, but we must persist. We persist by relying on the Red Cross, Red Crescent, and Red Crystal emblems. I'm sure you're all familiar of those shots of the big white Land Cruisers with the Red Cross on the side. So these emblems mark our staff, our vehicles, and our facilities as protected under the Geneva Conventions. And this is in concert with an array of complex, security protocols, risk assessments, and the like. This means that quite often we'll have bunkers in our compounds, sometimes hidden or secret exits for cases of emergency, or sometimes sandbags placed around staff, sleeping quarters, to reduce the impact of any potential projectiles. We persist by abiding by our fundamental principles and ways of working. These principles are based on the vision of Henri Dunant, the founder of the Red Cross. And I'm sure many of you here have already heard the story, but yes, based on him witnessing the battleground in Solferino in 1859. Among our 7 fundamental principles, our impartiality, neutrality, and independence mean that we provide assistance based purely on humanitarian need and with no discrimination, that we do not take sides in hostilities, and that we maintain our autonomy to work in accordance with our principles and our mandate. So working via these principles allows us to build organisational acceptance with the armed actors and with the community. And this in turn enhances our safety of our staff and also our access to vulnerable people. These, along with our specific mandate under the Geneva Conventions, allow the ICRC to act as a neutral intermediary between warring parties. So an example of this, when I was working in Afghanistan, and this was prior to the current Taliban government, we had a program trying to ensure that the bodies of those killed in the conflict were treated with dignity and respect. This was basically a car and a driver that would cross the front lines, recover bodies, and return them to their families. The service was available to civilians, but also to combatants from either side. So this operated with the authorization of both government and Taliban. This meant that the vehicle could cross the front lines and go through territory of either side and do so safely in order to return bodies to their grieving families. And we persist with confidential dialogue with authorities for access. So this means we are able to foster relationships and trust with the armed actors, and it's essential for us to be able to do our work. This means we can speak candidly with people and authorities that may not be so open to dialogue otherwise, and that we rarely make public statements or denunciations. Our former head of operations, Dominic Stillhart, said that confidentiality is the key that opens doors for us that would otherwise remain shut. And I can personally vouch for this. As a result of our neutrality and confidentiality, the ICRC was the only international humanitarian organisation with substantial access throughout North Rakhine in the early days of the Rohingya crisis in 2017-18. Similarly, when I was working with the ICRC in detention, so I was looking at prisoners of war, and other detainees, because these people are particularly vulnerable, because we see, I mean, obviously they are reliant on the authorities to meet their basic needs, but also there's high risk of ill treatment or torture. And I can tell you, the other organisations that were working in the country did not have the access that ICRC had. They could not get into those places. And yes, it's important to note, different organisations work in different ways, and many can play really valuable roles when it comes to public advocacy. But for the ICRC, by maintaining our confidentiality, we could be there in those places to try to make changes on the ground. We would support healthcare for people deprived of liberty. We could visit vulnerable detainees, revisit them and follow their course through detention, which helps to reduce risks of ill treatment and disappearances. This is why we must not abandon our work. Secondly, we must persist in engaging with armed actors to foster respect for international humanitarian law. International humanitarian law, IHL, is the law that applies in armed conflict, and it has the objective of protecting those who are not or no longer taking part in fighting, and to limit the means and methods of warfare. Civilians, civilian infrastructure, hospitals, medical staff, they're all protected under IHL. There are specific protections for women and children, and the use of sexual abuse in armed conflict is prohibited and considered a war crime. However, we've all seen images on the television of potential breaches of this protection, and we see the same in the field. This is a truly alarming trend, and this normalisation of violations risks eroding this law and perhaps international law more broadly. Just for a second, think about that for a second, like a world where we have no limitations or rules around armed conflict. You know, this risks a major degeneration of behaviour in armed conflict, a race to the bottom. And sadly, I think we know it's going to be the civilians and the vulnerable people who pay the price. Here in Australia, we are fortunate. We live in a country where this may not affect us every day. But for many, many people around the world, this is not purely theoretical or academic. This is something that has real consequences every day. There are a range of factors that may influence non-compliance. At field level, we might be looking at things like resources, training, and discipline. While definitely not an excuse for breaches of the law, the reality on the ground, we might be looking at a cohort of soldiers that are undertrained, under-resourced, underpaid. Maybe they're under forced conscription. Perhaps stealing food from the local villages could be actually their only way to feed themselves. Perhaps they don't have the most appropriate or functional weaponry for their context. Perhaps in some environments, those orders from HQ didn't make it to the far away and remote outpost. We're also seeing around the world a lot of asymmetric conflicts, and this disparity in power and in resources often leads to the less resourced party using tactics such as suicide bombings and attacks on civilians and civilian areas. And I hate to say it, but what about the situation where one party is already breaching IHL? It could be tempting for the other party to think, well, you know, if they're not going to play by the rules, why should we? And again, it's civilians and the vulnerable that will face the severe consequences. Even when parties are willing to comply with the law, I've seen situations where there are disagreements over interpretations or implementation. So I worked once with an opposition armed group, and they purported to follow IHL. But they argued that because by virtue of working for the government, their opponents, local government personnel or representatives didn't count as civilians, and so they weren't protected. So none of these factors are valid excuses for breaching the law, but they do demonstrate that we face many obstacles on a daily basis trying to ensure that all parties adhere to IHL. But we must persist. We persist because we know that IHL is saving lives every day. I'm going to borrow from the amazing Dr. Helen Durham, who many people here know. She said in much more eloquent terms, but basically, we hear about these breaches, we see it on the TV, we see the horror stories, but what we don't hear are about the times that IHL is complied with every day around the world and the lives that it protects. We persist by speaking with all parties to conflicts. So this might be government armed forces, opposition groups, rebels. So when I meet with a commander, and we might talk about what the potential consequences of their tactics might be, they know that I've had the same conversation with their opponents. And we speak with all levels and functions. This might be high-level government officials, a regional commander, a military legal officer, or the young man at checkpoint. What does this actually look like? Well, this could be a training in IHL held at a nice conference centre. It might be an exercise at a military base, or it could be an informal chat at the outpost. We also have staff with different skill sets and backgrounds, so like weapons specialists, those with military expertise, legal officers and field delegates. And we persist by demonstrating to armed actors our fundamental principles, including, as I've mentioned, impartiality, neutrality, and independence. So I spoke about these before in terms of how they benefit us in terms of access to people, but they are also super important in terms of that dialogue and conversations with armed actors around observance of IHL. I mentioned also before that example from Afghanistan, the program collecting human remains. So on one occasion, I was called to go to a police station to negotiate the release of the body of a suspected Taliban fighter. So the situation was there'd been an attack on a police post. Several police were killed and some of the attackers were killed. And so there I was speaking with the police, and I got the sense they were not super impressed to see humanitarians there trying to collect the body of someone who may have killed their colleagues. But I spoke to them and explained that last week we had collected and returned bodies of 7 of their police colleagues. This service was available to both parties to the conflict, and that families from both parties deserve to mourn and bury their loved ones. So the body was released, and I like to think handled with dignity and care and returned to the grieving family. This is why we must not abandon our work. Finally, we must persist to improve how we work with communities that are affected by conflict. There has been somewhat of a checkered history when it comes to how aid and humanitarian organisations work with communities. And I think slowly the humanitarian sector has improved our approach to the communities where we work. So, we sort of started with the concept of community consultation, then community participation, and now more community engagement, which is, the idea is that is integrated into all phases of humanitarian programming and across all decision-making that affects the communities. So forms of this participation and engagement were used a little earlier in development work, which traditionally have longer-term projects. But it is a bit of a challenge for humanitarian workers in terms of how we can use this and implement these models in a conflict setting, how we can do so practically in a situation of extreme urgency and danger. You know, like, how can you really implement a deep community engagement in such a context? And when is it going to be safe to do so? Some communities, for example, like our communities here, might have informal or formal hierarchies. Some community members might be excluded. For example, people with disability, people who identify as LGBTIQ+, elderly, or the youth. And some topics might be seen as taboo, particularly those relevant to protection or around sexual violence. And what if, for example, the community agrees that they will give up some of their young boys, give them to the local armed group to fight, in return for the rest of the community being spared? I mean, this is a deployment of the agency of the community, but obviously one that would have pretty serious protection consequences. So, you know, the safety of community members has to always be at the fore. And as I said before, neutrality is really important when we're looking at protection and assistance. So we know that affected communities do and should play a vital role in their own protection. And as humanitarians working in conflict, we also know that we have to be really careful and consider how we can engage with communities, how we can do this without creating any further harm. It is a challenge, but we must persist. We persist by acknowledging that local communities are the experts in their own situation and their needs. And so we listen to them. We hear their stories. So this is, it's practical. This is something like me sitting in the wards at the local hospital in Afghanistan for hours and, be talking to the wounded people or their families, trying to work out, how they were wounded, for example, and how else they're impacted by the fighting. So this would inform how we work, and also how we engage with armed actors, having a better understanding of how the conduct of hostilities are taking place and affecting civilians. And we persist by listening to all community members, being sure to include any that are particularly vulnerable. And this, as was said in the opening, vulnerability can change in different contexts. So this may include, again, people with disability, elderly, LGBTIQ+, and youth. In some places, women, for example, are not very keen to speak with outsiders. And I remember a time sitting in a dark room on the floor in this home that was made of bamboo and toddy palm leaf. And I was hoping to get a group of women, but I only ended up with the wife of the village leader. So, okay, we sat there and we started chatting. After a few minutes, I saw a young woman's face peering around the corner into the room. And she stood there silently for a while. And then after a few minutes, she joined us. After a few more minutes, another face, another woman. Then I think a mother and her baby, and more women. You get the idea. After an hour, it became quite raucous, a very lively discussion around things from breakfast meals to their children and to why my husband had not bought me a gold ring. Sorry, Mark, but the ladies were not very impressed. The women were grateful to have that opportunity to tell their story and their experiences during the conflict. And then obviously I gained more insight into how the conflict was affecting specifically children and women. And we persist with community-based protection. So the idea here is that we sit with communities while they talk about their threats, their priorities, and what they currently do to respond to those risks. And then we might brainstorm, are there other responses? And is there a need for outside assistance to support these? So this might be, an example would be perhaps a community needs to go north to get to the health clinic. On the way, there's a checkpoint. People are being beaten at the checkpoint and the women assaulted. So maybe the community already has put some things in place. They know only travel in groups large enough to be safe. Women don't travel on their own, things like that. Maybe there's a nurse in the village with some basic training. The ICRC might look at supporting this through a mobile clinic, which is essentially a four-wheel drive with a couple of medical staff and some supplies. So this would support healthcare options within the village. And then at the same time, we would also be speaking with the soldiers at the checkpoint, or probably their superiors, to try to stop that abuse happening in the first place. So the idea behind this community-based protection, it's about decreasing vulnerabilities and trying to enhance and bring out the capacities within those communities. In North Rakhine, the water and sanitation team were working on assessments to work out whether there were sufficient hand pumps in different areas and whether they needed to repair or dig more wells, create more water points. And for this particular area, their findings were that there were, in fact, sufficient hand pumps. So we thought. By speaking with the women, we found out that actually they didn't want to go to that hand pump. While it was the closest, it meant travelling through an area that was deserted, and there were often sexual assaults en route. So the numbers of hand pumps didn't really tell the full story. It was only by engaging with the community that we could really understand the needs. And so we could install a new hand pump in a safer area quite easily. And then women didn't have to risk assault to provide water for their families. This is why we must not abandon our work. And this is why we must persist. So please think of these stories when you're watching the news and seeing those horrific images. And know that there are people behind the scenes who are working to assist and protect those impacted by the conflict. People like Shakib. He has been kidnapped twice, but he turned up to work every day to negotiate passage for the ICRC ambulance. And people like Nang Nangu, who talked with the village mothers about how they're coping since the violence. And know that IHL is saving lives every day, even if you don't see it. There is a place for hope. Last year, my husband worked in Gaza, and in the face of the devastation, one of the local guards at the ICRC field hospital in Rafah said to him, "Thank you for being here. It means we are not forgotten." Yes, there are many challenges to protecting and assisting those impacted by conflict. But we must persist, and we do persist. So thank you for your attendance tonight, and I'm very much looking forward to hearing from Kim. Thank you.
Thanks, Katrina. This brings back a number of memories for me also, actually. Well, thank you for coming, everyone. It's really wonderful to be here. And I, of course, wanted to thank the Red Cross team and Vanessa Goodall and my colleague, Tim. Obviously, I came here primarily to see Tim, but I'm very glad to be able to speak with you today. And also really delighted to meet some colleagues at the University of Tasmania Law School later tonight and tomorrow. I told my family that I was coming to Australia this week, and they were very excited because we actually lived in Sydney 40 years ago. I was in elementary school or primary school, and haven't been back since. So they were delighted and send you all their regards back from New York and California. And it did make me think a little bit about childhood here. We were in Australia because of my father's work. He was for many years a banker with what was then called Chase Manhattan. But before he was a banker, he was a soldier and a photographer. And one thing he told me on the phone last night, of course, was make sure you take some pictures. And I said, it'll be Tasmania. It's apparently quite gorgeous. I'll take a picture or two. But it was him who had taught me how to use a camera at all. And, lots of things you have to learn. Like you use a wide angle lens to capture the full breadth of something and see the context and the connection of the object you're interested in and what's happening around it. Or you widen the aperture, right, to let in more illumination when the light is low and you can't quite see what's in front of you clearly. And my mother is not a photographer. She wasn't, but she would chime in. The most important thing is don't take someone's picture unless A, you have their permission, and B, you can portray them with dignity. So we have been talking tonight about protection of civilians affected by armed conflict and forced displacement. And Katrina just walked us through so many situations in which we see how that has to play out and pose challenges on the ground. I thought that perhaps I could pick up from where she left off and take us to a slightly different space. So when, and it's a small percentage of the time, you have a situation of armed conflict that actually has its day in court, you don't have a trial without people coming to at least provide some testimony, right? Many of the people who have suffered atrocity crimes and been through so much, there's some tiny percentage, no one's measured it that I know of, but who become witnesses in an international trial. And for them, it can be a number of things, right? It could be incredibly cathartic, it could be incredibly terrifying, it could be both. But what they are searching for, I think, of course, on one hand, it's justice, whatever that might mean for them, and their hopes that the legal system will provide it. But ultimately, many people, at least in my experience, choose to come forward because they see the justice system actually as a means to an end. They see it not only as a retributive system, but as a way to secure protection, whether it's in the form of reparations, if there's a conviction at the end of the day, or just a sense of acknowledgement. So when they go back to their community, the story has been told and they perhaps will have some bond as a community that wasn't there before. I wanted to talk about protection, not in the literal sense, I suppose. I think lawyers working in these international criminal tribunals think about protection sometimes quite narrowly, right? It's, do we have official witness protection programs? Can someone testify in camera? Do we have security guards in the courthouse? And I thought that perhaps I would talk about protection with a slightly different understanding of the word. Not so literal, but the protection that comes from being seen and having the violations you have suffered be part of the record so that you can be part of a trial and partake in justice that way, but also protection and safety psychologically and emotionally while you go through that process. So as Tim said, the work that I do is not particularly light. I've worked and represented survivors of different forms of gender-based violence my entire professional career. So I will avoid speaking graphically about anything tonight, but just know that my work is about mostly women, but often I've had male clients who've survived atrocious things in detention, for example, but also children. So I want to talk to you a little bit first about gender-based violence and how at times it's a crime under international law and what that means for what we're able to provide in the justice system and how that may or may not provide protection, may or may not do harm itself. And then the other area that I've been working on in the last couple of years is crimes against and affecting children specifically, which may or not be forms of gender-based crimes. But I wanted to raise that also because this is an aspect of armed conflict that we know has always been there right in front of us. right? But unless we have really widened the aperture to see specifically where the experiences of children align with or diverge from those of adults, we won't account for them properly in our justice processes. So let's start with the gender-based crimes piece. You've probably, if you've thought about this or heard about this or studied this at all, we know that gender-based violence has been part and parcel of armed conflict since the beginning, I think. And we have had accountability for it to some degree. In fact, there's accounts of it, in prior centuries, but in the modern times, after World War II, we had in the immediate wake of that war, the UN War Crimes Commission, which guided domestic tribunals in investigating and prosecuting crimes committed by the Axis forces. And in fact, Australia, as Tim knows, led in the prosecution of many of those cases in the Pacific region. And some of the cases brought by the UN War Crimes Commission involved evidence of sexual violence, whether it was characterized explicitly or not. But there was some measure of accountability in some of those trials early on. And in the Nuremberg and the Tokyo tribunals, similarly, there was reference to gender-based crimes, mostly rape, and then some evidence of forced prostitution, as it was called, which were heard and included in some of the adjudication of war crimes and what is now understood as crime against humanity too. For the first half of the century, though, these weren't discussed really explicitly, right? We use euphemistic language. We talked about gender-based violence as violations of family honor, right? These were not, individual survivors were less important than what this meant for the family or the community unit. In recent years, we've made much more progress in the jurisprudence. So we have acknowledgement of forms of gender-based violence beyond rape by far. So we have, of course, in the statute of the International Criminal Court itself, there are many other forms of gender-based violence that would count as crimes, either war crimes or crimes against humanity. This could include forced pregnancy, maybe enforced sterilization, different types of sexualized torture, for example. We have sexual slavery as a crime under the Rome Statute. But then in case law, of course, this gets fleshed out even more, and we have made great progress in different tribunals, not just at the International Criminal Court, but at the court at Sierra Leone and in Cambodia, which really articulated how forced pregnancy can be a crime. This came out of the ICC, but then also forced marriage, which isn't listed in a statute, but was understood to be what we call the crime against humanity of other inhumane acts. And then more recently, and I think the university here did some really interesting work helping flesh out the crime against humanity of gender persecution, which is broader. This is not necessarily a sexual crime, but it is a crime that consists of a severe deprivation of a fundamental human right against a group of people motivated in part by gender. And there's more to that crime, of course, but this is a really interesting new crime that's being articulated more consistently certainly in the International Criminal Court, and it's picking up traction elsewhere in national systems also. So I just started this way because this is part of what happens when we as a justice community agree and promise to widen the aperture and let in a little more light so that we can see that there is a full range of gendered harms that people suffer in armed conflict, that they are fleeing and that perhaps motivates them to seek justice. But this is, of course, not where the list ends. That we have to let in more light so that we see how other crimes under the Rome Statute or other statutes may also be gendered, either in the form that they take or what motivates someone to commit them or the impacts, the long-term impacts. So it's not a classroom. I won't quiz you or call on you, but I'm just wondering if you could think for yourself in your mind, is enslavement a gendered crime? surely you can imagine, and you've learned from history, perhaps here in Australia, we certainly saw this in the United States, where the way slavery worked in our country was highly gendered. The labor that you were assigned, the rights specifically that you were deprived of, in many ways depended on whether you're a man or a woman. What about starvation? Is starvation a gendered crime in any way? It certainly could affect everyone in a targeted population. But do we understand the impacts? Do we understand the differential impacts sometimes, depending on gender? Are we articulating the impacts of starvation on a lactating mother, for example? Or do we know what prolonged, protracted starvation does to a young woman's menstrual cycle and what that might mean for long-term fertility? So these are potentially gendered considerations to take into account when we're looking at crimes that don't seem on their surface to be gendered. What about the intentional destruction of civilian infrastructure? What if we have evidence that maternity clinics are being targeted for some reason, or girls' schools, or delivery sites where you can pick up humanitarian aid, where men are more likely to gather in a particular community? At the end of the day, what's ultimately charged in these cases depends on many different competing factors. You don't charge everything you know is happening. You don't charge everything you think you can prove. The critical thing is, from the very, very start, do we have that lens on? Are we looking for the gendered way war happens? Are we looking for the different impacts that women and men and girls and boys and folks who fit in none of those categories suffer? So if we do that from the start, that is how we have a chance of gathering the right evidence, and that is how we secure the option of charging later. Now, this builds into cases. What you charge is one thing, and the judgment that you get is another, right? And we have, of course, had sort of a wider angled lens emerging in the courts and the judgments also, right? So courts are starting to understand the connection between all of these crimes in a way, and the different types of survivors who might present themselves in the conflict and in the evidence before you. So, you know, it was actually a while ago now, you might be surprised, but in the International Criminal Tribunal for the former Yugoslavia, several of those cases dealt with evidence of men and boys who had suffered sexual torture. And so that has been, I think, a survivor group that is not contested at this point, hasn't been for a long time. More recently, at the International Criminal Court, another group of survivors that had not been fully visible before, but has been accepted now, are children who served in armed groups and who were subjected to sexual violence within that armed group, actually. This was a question under international humanitarian law, right? Whether they are hors de combat, are they actually outside of fighting? Can they be considered protected persons under the Geneva Conventions? And the answer that came out of the Ntaganda case was yes, they can. They are protected. They are children. This is sexual violence. It's prohibited. Another case that came out and acknowledged another group of survivors was the more recent case of Dominic Ongwen at the International Criminal Court, which is part of that holding, and the reparations approach was acknowledging that children who are born of wartime rape are themselves direct victims of an international crime, which was not apparent before. We've had cases throughout the century knowing that children were born of violence like this during war, and they were never themselves entitled independently to any sort of reparation or acknowledgement. They were beneficiaries in a way. They were asterisks and footnotes to the crimes that their mothers had endured. So this is all to say that we are making progress in the jurisprudence, in the charging. We are starting to see more clearly what these gender-based crimes are under international criminal law. And as a result, when we gather that evidence and when we charge it, we're inviting a broader view of the conflict that may entitle more types of people or more types of access to justice and potentially reparation as a result. If we shift gears a little bit, it's an overlapping there's a bit of a Venn diagram in that these are related issues, but not coterminous. Crimes against and affecting children. This is another area where, as I said earlier, we just assumed, just like we know gender violence has always happened in war, we also know children are always affected by war, but they have not historically had much focus in either our conception of crimes or how we work with them procedurally or space in our processes. So what do I mean when I say crimes against and affecting children? Part of it seems obvious, right? Crimes against children. This is where children are direct victims of crimes alongside adults. They too suffer from bombings, from murder, from detention, sometimes torture as well. But this category also includes when children themselves, they're specifically targeted for harm, often precisely because they are children, because of their young age, or their place in a social structure, or their inherent vulnerability. Early focus on child soldiers, of course, in our initial cases at the International Criminal Court. This is our first couple cases did consider children, but really only in the child soldiering context. And then more recently, you're of course aware of the first application for warrant of arrest in the Ukraine situation, which focused mostly on the illegal transfer of children from Ukraine into Russia. But then we have another case you saw, I think recently, the application for warrant of arrest in the situation of Afghanistan, where a large part of that case is about the denial of girls' education, which is part of the crime of gender persecution alleged in that case. So these are crimes that are specifically targeting children for certain reasons. So then what am I speaking when I speak of crimes affecting children? I mean that in addition to the indisputable effects of crimes directly perpetrated against them, children also suffer indirectly. They may not be the intended or incidental targets of a crime. They are severely impacted by downstream effects. So, for example, consider the impacts of a parent's detention on a child, or parent's forced disappearance, or of displacement of the entire family, what that does to a child, interrupting education, disrupting their social networks and their ties to grandparents, their friends, their social development becomes impeded. In truth, like gender-based crimes, like I spoke about earlier, almost every crime under at least the Rome Statute could be a crime affecting children. So it is important to consider all of these things, whether we charge them explicitly, whether those downstream effects constitute a crime in and of themselves. It's critical for us to take these experiences and put them into the narrative of the case. And I'll tell you why. It may not be obvious. It's important because many of the crimes I'm talking about and the impacts on children affect their lifelong development and opportunity, their chances of educational attainment, professional development, their cognitive development. Starvation in a 5-month-old is very different physiologically in terms of the impacts than starvation in a 15-year-old or a 50-year-old, right? So if we fail to capture the very specific effects, God bless you, of some of these crimes on children, we are missing part of the gravity. We are failing to show the very significant impacts of some of these acts on children who may have very long-term cognitive, psychological, physical repercussions and consequences. And if we fail to capture that, then whether you're in a tribunal that awards reparations in case of conviction, or you're able to at least manifest in the narrative the needs that someone might need if they're going to engage in your system, we miss that opportunity entirely if we don't unearth the specific impacts on children. So what does this mean for protection in the way we do our work? Well, the Convention on the Rights of the Child provides that children have the right to protection, of course, but they also have the right to participate in legal processes that affect their lives. So, what does that mean? There's a tension there, in a way, because most court processes, at least at the international criminal level, are not yet fully equipped to work with children, actually. They haven't historically done so. So if a child wants to engage a legal process, particularly about war crimes or crimes against humanity, deeply serious, complex things in a court potentially very far from where they live, how do they do that and still be protected in the process? Is that tribunal, is that office of the prosecutor, is defense counsel, are the judges able to work with children safely without harming them in the process? How do we take both of these rights and all the other rights that children possess into account when we investigate and prosecute these crimes? Well, with great, great care. Taking a child rights approach to this work means doing many, many things. And I'll highlight a couple that we've been talking about quite a bit. And I take the lead on this from actually a colleague of Tim's and mine, a woman named Véronique Aubert, who until quite recently was the special advisor for crimes against and affecting children. She would remind us constantly that children are not a monolithic group. And I don't know how many of us in the room have kids, but this seems quite obvious, right? Even within one family, siblings are completely different often. And also across families, one 10-year-old is not at the same physical or cognitive development as that 10-year-old or that 10-year-old or that 10-year-old. And it makes zero sense at all to approach with any system a 5-year-old in the same way as a 10-year-old, as a 16-year-old. If you're a legal process, you can't have one size fits all for children. There is obviously great, great diversity among children themselves. And children themselves come with many different layers of identity. They're not defined solely by their age, of course. They all have a gender. They all come with some racial or ethnic background, perhaps a religious identity. They may be affiliated with a family that's affiliated with a political group. Children have intersectional identities and intersectional characteristics that may make them vulnerable in different ways also, or at least subject to targeting in different ways. And so we have to take all of this into account when we talk about just generally engaging children. So despite the challenges in understanding the differences among children, there are responsibilities for us to make sure that they do have the right to participate. And that means that we have to do so many things as an office, right? And I won't speak for the Office of the Prosecutor because I no longer work there. But generally speaking, even in national systems where I've worked, there's a good bit of fantastic practice for systems, perhaps in Australia too. I don't know, I haven't worked here on this. It's highly developed in many countries, how one would work with children in a regular domestic criminal case, for example, right? We have many cases of child sexual assault in the US, or children who have witnessed domestic violence in their homes, children who can testify or have been subjected to or suffered many other types of harms. We have specialized units for that in most jurisdictions in the US, and I presume here too. What we're asking children to do in an international criminal tribunal is quite different in a way. We don't always have the same protections, the same social workers present. So we have to up our game quite a bit when we are bringing them into a situation where they could be asked about things that have happened to them or that they have witnessed. And we have to fit that into a much larger mass atrocity, mass crime context. So it's important to make sure that the children's experiences are reflected. But if that means interviewing them, it requires intensive training in child forensic interviewing, for example, making sure you have psychosocial assessments done beforehand to make sure that we understand the child's cognitive development, their level of maturity, whether they have any sort of risks or security challenges that they themselves might not be aware of, that must be gathered from speaking to everybody around them, parents if available, guardians if available, country experts, whoever might be able to shed some light on whether this is truly in the child's best interest to engage with the process. It is difficult, and I think many colleagues who work in this space feel a lot of apprehension about engaging children, certainly interviewing them. And oftentimes it's much easier to decide not to do it, actually. And that is understandable. But if we are to honor the children's rights to participate in a legal process, we have to at least ready ourselves. So in the case that there is a child who is able to, wants to, and it is determined with them and with the people around them that it is in their best interest, are we ready to do that? Are we able to do that ethically and safely? It takes a lot of homework on our side, but that has to be possible. Otherwise, we ourselves become guilty of depriving children of the right to participate in the process. So I raise that because I know it's potentially quite controversial and provocative, but this is also a question that we deal with in these international crimes cases, and we are less equipped, I think, than many national prosecutors who deal with regular domestic crimes. And I just raise it because it is something we are struggling with and trying to increase our capacity to, so we can do that quite ethically, because children do, of course, have experiences that need to be reflected when we present the full story of conflict. The through line of all of this is that to do any of this work, to work with survivors of gender-based violence and children who might be affected by atrocity crimes, is you cannot ethically do it unless you take a survivor-centered or trauma-informed approach, right? You can't. And this is where I feel like my mother's interjection of don't take the photo unless you have permission and you can do it with dignity. I think obviously this is different than taking photos, and there's a lot more care that one has to put into the work when you're investigating and prosecuting international crimes. But I take that as a launching pad to just fill you in a little bit about how it works to take a survivor-centered and a trauma-informed approach to this justice work. A survivor-centered approach, as you might imagine, or as you already know from your own work, is essentially at its heart, it's just treating every survivor or potential survivor in front of you with respect and dignity, and acknowledging that each one has equal rights to care and support. They may be different or unique in how they present. They may react quite differently to their experience of violence. They may be affected by trauma if it was a traumatic event. But it is important, of course, to know what they need, to understand what they want out of engaging you, and try to accommodate that and give them every decision-making power possible in the context of that process. And ultimately to treat everyone with kindness and respect in that process. Adjacent to this, largely overlapping with this perhaps, is the trauma-informed approach, which is one that is aware of and responsive to trauma and its impacts on individuals, right? This is one that promotes healing and recovery in addition to whatever else you are doing with this person. So these seem obvious, and I think most of my colleagues embrace these concepts at a theoretical level, but it becomes quite hard to operationalize this. How do we actually do it? And it is not easy, but I raise it because this is one of the key aspects of protection, actually. It's not about necessarily simply having the security guard at the courtroom door, or whether you can use a procedural rule to save someone having to tell their whole story in court. These are important procedural measures. But truly at the heart of it all is this. It's, are we able to take a survivor-centered and trauma-informed approach to the work? For me, part of this is understanding disclosure. And I don't mean disclosure in the lawyer's sense of the word, which is when you have to show information to opposing counsel, right? Essentially. we had studied barriers to disclosure of gender-based violence in humanitarian settings in 5 different countries for years, trying to understand, what is behind this challenge of underreporting for these crimes. We know in so many different situations, both domestically and in regular life, peacetime, but certainly in armed conflict, there is a huge challenge in knowing what exactly is happening in terms of the gender-based violence in the community, and to what level, incidence, prevalence, whatever measure might be relevant in order to understand the volume or the numerosity of the situation. Underreporting, one of the main barriers, of course, there are many reasons, from individual to structural and international level challenges, but most of it comes down to stigma and people's the way that gender-based crimes in particular are so deeply, deeply stigmatized, and there's so much taboo speaking about it. And so for survivors to come forward and share anything about what happened to them, particularly in an armed conflict situation where they have many other challenges and many other priorities, justice is often the last thing, or engaging the formal justice system is the last thing that they may prioritize in displacement or in the middle of acute conflict. And so it's easy to tend to the other needs in these emergency situations. It makes it easy not to disclose. But when you have a moment when the stars do align and there is an opportunity to share what happened to you, will you? Will you open your mouth and explain to the healthcare worker or the investigator who may have come into your community what happened to you and share this type of information? This is a protection issue also, because once that someone has exposed that has happened to them, particularly in a fragile context, if the community around them, if there is retribution or if there is any abandonment or rejection by a community, this can have incredibly, particularly dire consequences in displacement, or when you rely on community resources for protection and for access to resources and for information. And so people who are already often marginalized or ostracized because of these stigmatized experiences, this can be an exacerbated risk in armed conflict or displacement. And this makes it quite hard, I think, for many people who are trying to investigate these crimes to access people willing to talk to them. It is a dilemma how much you try to push in a community. You want to know, you believe that these types of harms have happened. You want to be able to show it in the record, as I was talking about, because we have widened the aperture here. We're seeing that it must have happened. We have healthcare records, we have human rights reports, but you can't possibly force a survivor to come and talk to you. And so we end up in this bit of a puzzle, actually. And so how can we make an enabling environment and what can we do to assure survivors of gender-based crimes, or even families and children, to come forward and speak about these forms of violence that they may have suffered? It takes time. Taking a survivor-centered and trauma-informed approach never expedites the process. To be honest, it usually slows it down a bit, because you have to take time to learn the context, to learn how social norms work around gender, around violence, around children, about where children fit in a social hierarchy. If you're working through interpretation, you have to vet and really prepare your interpreter, because they can make or break any interaction, any attempt to establish rapport with the person. You may be completely open and empathetic, but if you have to work through someone who has any sort of hesitation about speaking about gender-based violence, or has sort of a reaction to someone they may be judging for having had this experience, or someone who just simply doesn't know how to speak calmly and clearly to someone who's under 18 in the case of a crime against or affecting a child, then you're blocked. You're blocked by your own, perhaps well-intended interpreter. It takes time to schedule the psychosocial assessment that is required. It's necessary before speaking with anyone who has any indications of past trauma to make sure that they are fit to be speaking to you, to make sure that it is in the child's best interest, to make sure this is truly what somebody wants to do. And it takes more time to actually do the logistical scheduling. It takes flexibility. If you take a survivor-centered approach, you cannot say to someone, okay, you show up, we're going to talk, we're going to do a 3-day interview starting next Monday, right? Does this person have a job? Does this person need to be somewhere? Do they break for prayer 3 or 4 times a day? How do they get to you? All of the obligations that a survivor-centered approach puts upon us take time and resources, actually. And so yesterday in Melbourne, somebody asked me, actually it was Monday, asked, so if it takes more time and resources, how do you possibly convince colleagues who are already under-resourced and strapped for time to do this? And it's an incredibly good question, because it is a challenge, I think, that many people face in this work. You don't always have the luxury of time to spend as long as you need to with somebody. You don't always have your choice of interpreter. But the good thing, the thing I can assure colleagues who are unsure about whether they should be, if it's worth spending this much extra time and money on developing rapport with the person they want to speak with, is that you will always get, if they choose to speak with you at the end at all, you will always get higher quality information if you are trauma informed and you understand why someone can't tell you their story in a linear fashion, perhaps. Instead of dismissing them as not credible, you'll understand that perhaps this is an impact of trauma, actually, and I need to ask a different way, or I need to give more time. And you will have more durable evidence, because if you don't offer the type of support and understanding people might need, you won't understand from them what their risks are, and you will lose them in a few years. By the time you're ready to go to trial, you may not have access to them anymore. So it is important from a purely pragmatic point of view, if you care nothing about the well-being or dignity of the survivors in front of you or the children in front of you, if you only care about your evidence collection, then be satisfied with that. So just a few additional points about some of the challenges of taking a survivor-centered approach that I think that I have been mindful in the last several years, and I think many of my colleagues are understanding and working through, is that particularly for gender-based crimes, not all survivors see themselves or their experiences in the same way. And so even if we're looking in the evidence and we see what seems to be indications of, say, mass rape or separation of men and women for different treatment and different purpose, it bears reminding that the people in front of us, when we speak with them, they may not actually see their experience in the same way that you do. I'll give you an example that I've been thinking about recently. And alternately, they may have an experience that they understand in a way that you may not understand. So there was research. I was at Berkeley for about 10 years before I moved to Washington University. And some of my colleagues had done years of research in Guantanamo Bay and at the detention facility there. And they were alarmed by, in the data, the interviews they were conducting with detainees, the number of men who indicated, after a considerable amount of rapport was obtained, right, and just developed, that they referred to rape. They used the word rape many times. and which of course alarmed my colleagues quite a bit. And they were wondering, how is this system, what is happening in this detention facility? And it turned out that the reference was actually referring to the cavity searches upon being registered, being brought in. And this, of course, to many of the men felt they experienced it as rape. And it was not exactly what the researchers had in mind, but it was they understood that this was the meaning of that act and that experience to the people they were interviewing. And so similarly in investigations, sometimes we'll have people who describe their experiences in different ways, and it can work in two ways. It could be the language that they use doesn't refer or indicate a sexual crime at all. Maybe they're using euphemistic language. Maybe they don't actually see what happened to them as a sexual violation, or it might be the other way, in which they are using language that they have heard or they believe that it is the violation that they should be naming, when actually their feelings about, they have some ambivalence about identifying themselves as rape survivors, for example. I think if we take the time not just to listen to somebody and how they describe their experiences without trying to characterize it as a crime right away, then we may have a better chance of understanding what that act and that experience meant to them. And later, when it comes time to choose your charges, you can do the qualification and do the characterization more faithfully based on just the description of the conduct that they have given to us. This, of course, takes a lot of investment in learning the local context and connotation. What is considered a violation, what is considered sexual in one context to one group of people may not be the case everywhere. There is a woman who had described having to remove her headscarf as forced nudity, which we have acknowledged in tribunals could be a crime, the form of inhumane act. But is it? We haven't gotten that type of, we haven't presented that in cases as such, but perhaps it was worth considering that if that was this woman's experience of what happened to her, there is meaning there, and that should be addressed somehow in the narrative of the case, even if it's not charged. The last thing that I would point out about taking a survivor-centered and trauma-informed approach is, and this is again another challenge that we're still working through and isn't always resolvable, but it's a question of timing. One of the challenges is that when we have these cases, they often are on timelines that don't match survivors' timelines at all, right? So you have an investigation phase, maybe you're analyzing your evidence, the time for trial comes because you managed to secure the arrest of somebody who's been accused of the war crimes or the crimes against humanity before you. None of that timing is necessarily in sync with the timing that survivors have for themselves. They may be ready to engage in that process. They may still be recovering. They may be dealing with a million other things in the course of forced displacement or resettlement, perhaps. It may be that they grew tired of waiting for justice. And so part of the challenge is trying to figure out, how do we align these clocks a little bit and get them in sync? Is it possible that we keep different doors to justice open for people so that when, as in the case of a Bosnian woman who was in her 70s, for her, she did not disclose, she wouldn't mention what had happened to her until decades and decades later when her husband finally passed away. And then she felt free to speak because she hadn't wanted to break his heart. By then, the cases that she could have been part of were over. She couldn't participate. But she sought some solace. She received some solace in the fact that justice had been delivered in some ways for other members of her community. So I think that the timing will be critical in terms of protection also. If someone doesn't feel safe in coming forward, they can't come forward. If structures are not in place to protect them, if society and the way we see these crimes hasn't shifted enough to allow someone to return and be part of a community after they've testified and become public and known in their experiences potentially, is that demotivating? Does that disincentivize coming forward at all and compromise security in the long run? And what are we doing to affect that type of community change? This is not the work of lawyers or the courts, but this is where I think prevention really depends on other actors, right? We have a narrow scope in protection work, but the greater part of prevention comes from perhaps humanitarian actors, as Katrina was explaining, but also it may be, and this goes back to, I think, Tim's reference to the need to have cross-sectoral and interdisciplinary work in this field. Prevention is not the language of lawyers, but it is a practice in the field of public health. And so if we can do our work in conjunction and alongside behavior change work and stigma reduction work, this is part of how we will ensure that people who move through our processes can move and still remain parts of communities that don't judge them for what happened to them and can understand why they decided to testify in the first place. So I think that we have seen much progress in the acknowledgement and shedding light on some of these crimes, different forms of gender-based violence that have occurred, different forms of crimes that affect children in recent years. And we're starting to see the context and the connection to other crimes so that they're not isolated in how they're presented in court. And we are certainly making progress in terms of acknowledging the need to do this work with care and engage our witnesses, engage the survivors with dignity. But it remains to be seen whether this will continue to progress right now in this moment in time when so much of this work, gender-based work and protection work, are being threatened by shifts, geopolitical shifts in funding for services that are protective, that are attuned to gender-based violence and to children's needs in displacement and armed conflict. So I feel hopeful because we have made fundamental progress in how we understand and what we're waiting to see. But it's funny to speak to you in this particular year when we have, particularly from my country, such disruption in the underlying structures and funding that support and enable these communities to be safe to begin with and have justice structures like the international tribunals to seek and to approach if they want to engage in prosecution. I don't know what the answer is here. I hope that, well, I hope that we have some political change back in the States very soon. But I've been thinking about how Australia has the potential to be such a leader in this region, actually, with your court system and your resources. Is it possible to do more of this work through universal jurisdiction in your own courts? Is it possible to help in the region where we see these crimes happening in Sri Lanka, in Myanmar? What can be done through your system and with your resources and support? Thank you. I'm going to leave it there, but I hope that in our conversation, you can ask questions about how we operationalize this work for survivors going forward. Yeah, thank you. Sorry.
I just want to thank you both so much for those really insightful, rich talks. And we will have 2 questions for our speakers. I have made a bunch of questions, but in the interest of time, I'm going to hand over to the audience. So if anyone has any questions that they would like to start with, we have one at the back up here.
I hear your sensitivities towards various cultures. However, many cultures don't regard it as sexual assault. When they marry off young girls, we have currently an ad on television where an 11-year-old has been married off and has 3 children before she's 15 in dire circumstances. And I'm just wondering, balancing that with what is an assault when it's in another sphere, it leaves me very disconcerted. And the other thing is, if you're listening to all this harrowing experience from others, how do you hold yourselves together? And who helps you to support yourselves?
Thank you. I think it is true. There are many different traditions and understandings of gender and roles in a society. And at least at the international crimes level, part of, and I could have explained this more, I think, the crimes that we're looking at they're mass crimes, and they may be, you might have forced marriage, but in a very specific context. We would look at that as part of, either it's you can show the connection between those forced marriages and an attack on a civilian population, for example, or if the forced marriage itself is associated somehow with an armed conflict, whether it's an international armed conflict or something that's not international, is more within the domestic, within the boundaries of a single country. And so in a way, it's, if those connections are articulated and you show that forced marriage itself is an interest, like an integral part of how that the purpose of the attack is being played out, or it's related to a conflict, then that is the type of the crime that we would be prosecuting. It doesn't touch necessarily some of the traditional practices that may be happening in a peacetime conflict. So I'm not sure that all of the cultural practices that might be quite different in different places would fall under the scope of what we would be investigating or prosecuting. We saw forced marriage in cases in Sierra Leone and in Cambodia where the relationship was very clear. Children would be abducted, and whether they were boys, often they were made to fight in Sierra Leone, and the girls were put into domestic servitude or married off, in quotes, to different commanders and soldiers. And so that has been one of the typical frames in which we see forced marriage clearly associated with a conflict. In Cambodia, it was part of the Khmer Rouge attempts to recreate a whole proletariat population and community in the 1970s. And so it was an intrinsic part of that effort. And so this is the context in which forced marriage would come before us. And then in terms of taking care of myself, I think I spend a lot of time with my daughter, but also I feel like you get a lot of reward from working with other people who are committed to this work, I think.
Yeah, my question is for Katrina, and you mentioned some of the difficulties in negotiating access to affected populations in times of armed conflict. And I was wondering if you could reflect upon times in your experience where IHL, as like a legal framework and objective body of law, has been effective in negotiating access, perhaps by appealing to minimum standards of protection or appealing to the interests that the parties might have in how it looks to reflect compliance with IHL, versus experiences where, for whatever reason, IHL is denied or it's politically sensitive and not feasible, and maybe whether you appeal to other legal frameworks or traditional norms, cultural practices, whatever it might be to gain that necessary access. Thank you.
Yeah, thanks for that question. I think I'd firstly start by saying, while our work is all based on that framework of IHL, we're not really busting it out that often in terms of day-to-day work. You know, if you're trying to negotiate access to a prisoner of war camp or something like that, as you sort of alluded to, you're going to be more trying to bring out, you know, practical aspects, trying to work out what potential blockages may be and how you can problem solve to get that access or try to overcome some of the reasons behind the problems. So, for example, with prison access, you know, we might know that, you know, there's some scabies in the prison, which there often is. You know, any authority in charge of a prison or a prison camp does not want scabies going through the whole camp. So, you know, by recognizing that, and, you know, the ICRC has a health team that can support health within the prison, that might be a way to open doors. Yeah, I think being practical, problem solving, you know, sometimes the difficulties are not on purpose. Sometimes it's just the armed actors have other priorities. And it's about getting in there and going, okay, what do we need to do to get this done? You know, I had a case where people were trying to get to the hospital for emergencies, but their movements were being restricted at checkpoints and by administrative processes. So really, my work was not that exciting. I literally just had, you know, talk to all the relevant people. What process can we put in place? So we got a process agreed to by the civilian administration and also the military, whereby the village leader, in cases of emergency, could call one of the local commanders and they would speak to the local checkpoints, etc. And, you know, there was a process, which is just being practical, I think.
Great. Thank you, Katrina. We have unfortunately run out of time. Before we conclude, I will actually invite Vanessa Guru, the State Director of the Australian Red Cross, to deliver a vote of thanks.
Thank you, Cleo, and good evening, everyone. It's an honour to deliver tonight's vote of thanks on behalf of the International Red Cross and Red Crescent movement. This year's oration, Safeguarding the Vulnerable in Conflict, has challenged us to think deeply about how we protect dignity, defend humanity, and hold space for hope in the face of violence and displacement. To our presenters, Katrina and Kim, thank you for the clarity, courage and humanity you brought to tonight's conversation. Your insights have illuminated not only the legal and ethical dimensions of protection, but also the lived realities of those most at risk. Katrina, your grounded field-based reflections brought the realities of humanitarian protection into sharp focus through stories that moved us from muddy roads in North Rakhine to tense negotiations with police in Afghanistan. You shared the deeply human dilemmas of accessing vulnerable communities, engaging armed actors, and upholding dignity in conflict. Your tribute to our national staff who persevere despite their own loss, danger, and grief reminded us that the heart of humanitarian work lies in their courage. You've shown us that protection is not just policy, but persistence, and humanity in its most practical form. Kim, your reflections helped us see the justice process not just through a legal lens, but through a wide-angle view, one that captures the full spectrum of harm, dignity, and human experience in times of war. Your insights into gender-based crimes and the complexity of crimes affecting children were deeply compelling, reminding us that justice is not only about legal outcomes, but about how we see survivors, listen to their stories, and respond with care. You challenged us to slow down and to widen our aperture so we might better understand the nuances of harm and survivor voice. Through your words, we are reminded that dignity begins with consent, that justice must be shaped by those who lived through the harm, and that the road to accountability is not only through the courtroom, but through community, healing, and recognition. Together, you've both brought clarity and compassion to one of the most urgent questions of our time. How do we uphold the laws that are meant to protect people in conflict, especially those most vulnerable to harm? As we've heard tonight, that question isn't theoretical, it's real and it's urgent. Just this week, the International Committee of the Red Cross made a rare public statement about the situation in Gaza, reminding the world that too many civilians have been killed, too many civilian infrastructures destroyed, too much suffering inflicted. But it went further, calling for the rapid and unimpeded flow of humanitarian relief and for all parties to respect the rules of law. And that's just one crisis among many. While our movement does not take sides in conflict, we stand always for humanity. And tonight we have been reminded why that matters. The oration is not just a space for listening, it's a space for reflection and for carrying ideas forward. So perhaps the question we leave with tonight is this: what do we do with the knowledge we've gained? Can we share it in our homes, our workplaces, our classrooms, and our communities, and help build understanding of the laws, rights, and protections that civilians are entitled to in war? And can we, in our own ways, stand for the protection of the most vulnerable, even when we feel far away from the crisis itself? To everyone here in the room and those joining us online, thank you for showing up with curiosity, compassion, and a willingness to engage in complex truths. To our partners at the University of Tasmania, thank you for your continued commitment to the oration and to public dialogue on critical humanitarian issues. And to the team who worked behind the scenes to bring this event together, your efforts are truly appreciated. Thank you again for being a part of this important conversation, and I hope to see you again next year. Thank you.
Thank you very much, Vanessa, for those excellent words to sum up what were two fascinating talks. So to finish, please join with me in once again thanking our two excellent speakers for this evening and give them another round of applause to conclude. So thank you all for attending tonight and taking part in tonight's conversation. I'm sorry we didn't have time to get through all of the questions that we had in the room and online, but we hope you can leave enriched by these conversations and have a safe and happy evening.